Your Honor, my name is Lisa Cline. I represent the defendant, Mather Organic Distillery, to whom I will refer as Mather. The parties here disagree on the introduction of two items of evidence. First, plaintiff wishes to introduce evidence that is external to the written contract the parties signed. The contract stated that the price per crate of gin would be, quote, $350, subject to a timely payment discount, end quote. The contract did not define the term timely payment discount. Plaintiff alleges that during a phone conversation between plaintiff and Mather that occurred the same day the parties signed this written contract, that the parties agreed that the timely payment discount would be 15% on any amounts paid before the contractual payment date. Plaintiff wishes to introduce the phone call as extrinsic evidence that the parties contracted for a timely payment discount that would be 15% on any amounts paid before the contractual payment date. Section 2-102 of the Uniform Commercial Code states that contract terms that are, quote, set forth in a writing intended by the parties as a final expression of their agreement, end quote, may not be contradicted, quote, by evidence of any prior agreement or of a contemporaneous oral agreement, end quote. Section 2-102b states that such a contract may be, quote, explained or supplemented by evidence of consistent additional terms unless the court finds the writing to have been intended also as a complete and exclusive statement of the terms of the agreement, end quote. Here, both parties signed a document that included extensive material terms such as price, delivery date, number of crates, and type of gin. The document also contained an integration clause that provided that the written contract was the, quote, complete and exclusive embodiment of all terms agreed to by and written between the parties, end quote. Thus, because the parties intended for the written contract to represent the final, complete, and exclusive expression of all agreed upon terms and conditions, the contract is governed by the UCC's parole evidence rule. Additionally, because the parties' alleged phone conversation allegedly took place the same day that the parties signed the contract, the conversation was likely a prior or contemporaneous oral agreement, the introduction of which as evidence is barred by Section 2-202. Additionally, the parties' integration clause uses the terms complete and exclusive. Given that both parties signed this contract, the court can find that the parties intended the contract to be the complete and exclusive statement of the terms of the agreement. Thus, plaintiff cannot use the exception in Section 2-202 to argue for the admission of the phone call as evidence in this case. Further, the absence of a description of the timely payment discount indicates a lack of importance of the term to the parties, given that the parties went to the trouble to memorialize the material terms of their agreement in such detail in the written document. 15% is a large discount. It seems unlikely that the parties would leave such an important term out of their written contract. In any event, plaintiff offers no evidence that Mather agreed to the alleged timely payment discount terms. The second issue involves Mather's request to allow two experts to testify about their experiences in the distilling business. Plaintiff alleges that the presence of trace amounts of genetically modified organisms, or GMOs, in the gin constitutes a breach of an express warranty in the contract, stating that the gin must be, quote, all natural, end quote. Mather wishes to introduce the expert's testimony as evidence that, in the gin distilling industry, small amounts of GMOs are normal in gin, and that the amounts at issue fall within industry expected norms. Section 2-202A states an exception to the general parole evidence rule, stating that written contracts that the parties intended to be the final expression of their agreement may be, quote, explained or supplemented by usage of trade, end quote. Section 1-303C defines usage of trade as practices or methods of dealing that are so regular that parties participating in the trade are justified in expecting that other trade parties will participate in those practices. The section also states that in order to prove the existence and scope of such a practice, the party must utilize facts, and trade usages must be, quote, well settled, end quote. Additionally, the court in Nanakuli Paving and Rock Company versus Shell Oil Company noted that usage of trade is, quote, important enough to be admitted always, even for a final and complete agreement, end quote. To demonstrate that the presence of trace amounts of GMOs in gin is accepted uses of trade in the gin distilling industry, Mather must provide this court with facts as per Section 1-303C. The testimony of the experts will provide the court with the facts necessary for the court to determine if the presence of trace amounts of GMOs in gin do indeed fall within the industry expected norms. In other words, if the practice is well settled. Therefore, because the expert's testimony falls within the parole evidences rules exception of Section 2-202A, this court should allow Mather's experts to testify. Thank you.